You can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do.
As the defense presents its argument, we see a clearer picture of Mr. Hopkins' situation. The setbacks after losing his tethered job, his effort to pivot into an online cybersecurity.
Represent yourself.
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
Sorry. I'm here because I'm told to be here today, Your Honor. That's all.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this: you want to represent yourself in this?
Yes, Your Honor.
You don't want help, so I'm going to do this. I'm going to apprise you if you wish to represent yourself. You're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to, and the court will not play favorites, the court will not help you out, the court will not be assisting you. You understand that?
Now it's starting to make sense. Turns out this guy's not just your typical sovereign citizen clown. He's in court on a meth charge. That adds an entirely new layer of chaos. And just wait.
I would like to first file a request for suppression of this evidence until
suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained, and because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened. I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda.
Now this guy's out here claiming the officers targeted him and that he's been harassed for 3 days straight. But let's be real, judging by how much he's running his mouth. It sounds more like he's the one doing.
Court recalls case People versus Daniel McGraw.
Pass along to the people.
In your honor.
State your name.
Daniel Magoo.
All right.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand-delivered it to the defendant, as well as handing the copy to the court. If I may just respond to the record.
Yes.
Thank you. So this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that. As the court is well aware, depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay,
All right. You got any response to the people's response? No, motion denied.
thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely, Art. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people executed a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I can show you it. It's quickly available here for me to show you, but he's really within.
I really would be
grasp.
The defendant showing anything to the court that he has not disclosed to the people.
So, given that I do have FOIA on my CAD records for the dispatch record of the police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is. I've known him for 15 years. I was with him throughout the course of the night, and
So you want his medical records?
I want to first of all subpoena him to get his witness statement on record officially, and I would also like his records due to the nature of why they.
Not going to order.
This guy is either completely unhinged or just full-on performing for attention. Because seriously, if he actually worked with his attorney and stopped committing crimes, he'd probably be out.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Here, the judge turns up the pressure, cutting through the narratives with rapid-fire yes or no questions. Was the taser actually used? Was a firearm pointed? And exactly which officers sustained real injuries? The courtroom shifts into a scramble, as both sides work to square the official reports with what the video footage appears to show.